Pros and cons. The U.S. Citizenship and Immigration Services, USCIS, and the Department of State estimate that each year 450,000 U.S. citizens marry foreign nationals. They also believe that a large percentage of these marriages are entered into solely for immigration purposes. A great deal of effort is undertaken by the various U.S. government agencies involved in the immigration process to scrutinize each international visa application. Everything must be in order, or you risk your petition or application being rejected, even for minor procedural errors. This level of scrutiny, while making sure that only legitimate petitions are approved, has slowed down the visa process. The K3 visa, sometimes called the marriage visa or spousal visa, was adopted by U.S. Congress and went into effect in August 2001. It was designed to sidestep the long delays in USCIS processing for immediate relative petitions for bringing a foreign national spouse of a U.S. citizen into the U.S. At the time it was adopted, it was taking 2 years or more to process an I-130 visa for the spouse of a U.S. citizen. The new K3 visa regulations were designed with a view to shorten the processing time for bringing a K3 spouse to the U.S. from years to months, a goal that has, for the most part, been achieved. The K3 spouse visa and K4 dependent visa, an overview. The K3 spousal visa. The K3 visa category is a visa category that allows the spouse of U.S. citizens to enter the U.S. and wait for the availability of an immigrant visa. The K3 visa is actually a non-immigrant visa, and the recipient of a K3 visa does not mean, or the receipt of a K3 visa does not mean that the foreign national spouse of a U.S. citizen will become a legal permanent resident immediately upon their arrival in the U.S. However, the K3 visa does allow the foreign national spouse to travel to the U.S., live there with her U.S. or his U.S. citizen spouse, while they are waiting for the immediate relative immigrant petition processing to be completed. Upon entry as a non-immigrant K3, the foreign national spouse may file to adjust status to a lawful permanent resident. It is noteworthy that the application for a K3 visa by the foreign national spouse who is married to a U.S. citizen must be filed, and the visa must be issued by a U.S. consulate in the country where the marriage took place. The amount of paperwork involved in filing for a K3 visa is almost double the amount required for a fiancé visa. K4 visas, the unmarried children of a foreign national spouse. The unmarried child or children of a foreign national spouse who are under the age of 21 can be included in their parents' petition and will receive a K4 visa that will allow them to travel to the U.S. with their parent. No separate petition is required for them. However, if the child was 18 years of age or older at the time the marriage of their parent to the petitioning U.S. citizen spouse took place, then although the child can receive a K4 visa and enter the U.S., that child cannot obtain a green card through the U.S. citizen step-parent. The K4 visa for that child will simply expire after the 2 years, or when that child reaches the age of 21, whichever occurs first. To qualify for the K4 visa, the applicant must be a child under 21 years of age of a person who qualifies as a K3 visa holder. Children of foreign national spouse of a U.S. citizen who are married or are over the age of 21 cannot receive a K4 visa. Let's take a quick look at the case. Juan, a naturalized citizen of the U.S., got married in his hometown in Mexico last week. Upon returning to the U.S., he started the immigrant visa process to bring his new wife to the U.S. Juan, having gone through the immigration process himself, contacted an immigration attorney before going to Mexico to get married. He found out that he will have to file a petition for alien relative for his wife once he gets married. He also found out that it could take several months for the USCIS to approve the petition and for his wife to get her immigrant visa to travel to the U.S. But the attorney told him that there is still hope. Although the K3 visa, there is still hope through the K3 visa. He said that with a K3 visa, his spouse could come to the U.S. and wait for the visa processing to be completed. Based on this advice, Juan took several forms with him that his wife would have to complete and sign. That way, he was able to save additional time and not have to send the forms back and forth in the future. With all the completed forms and having obtained the copies of civil documents, his birth certificates, his wife's birth certificate, and their marriage certificate, that he needed for the petition process, Juan was now ready to file the petitions and bring his wife to the U.S. to live with him. Let's look at qualifications for the K3 spouse visa. To qualify for a K3 non-immigrant visa, you must show that 1. You are married to a U.S. citizen who has filed a relative petition, the Form I-130, on your behalf. 2. You must be seeking to enter into the U.S. to await the availability of an immigrant visa. And 3. The relative petition filed by your U.S. citizen spouse must still be pending. Who cannot use the K3 visa? The K3 visa can only be obtained by a foreign national spouse of a U.S. citizen. The wife of a permanent resident cannot receive a K3 visa. If the marriage took place while the foreign national spouse was in the U.S. in another temporary visa category, or was here on a visa waiver, the foreign national spouse must depart the U.S. in order to be eligible to receive a K3 visa. Because of the complexity of the situation, we recommend that you seek the guidance of an immigration professional before making any decision about marrying a foreign national who is currently in the U.S. on any visa other than a K1 fiancé visa, which you sponsored. Procedure for obtaining the K3 visa for the spouse. Marrying a U.S. citizen in the U.S. or abroad. There are different options available to foreign nationals depending on where the marriage took place. If the marriage took place outside the U.S., then you must generally obtain a K3 visa or wait for a non-immigrant visa to enter the U.S. As far as the U.S. government is concerned, a marriage that takes place overseas is a valid and legal marriage, provided it is recognized as a legal marriage by the government of the country in which the marriage occurred. If you intend to get married in the U.S., you need to obtain a K1 fiancé visa to enter the U.S. Upon entry as a K1, you must marry your U.S. citizen fiancé within 90 days, and then you can immediately file for adjustment of status to get the green card based on that marriage to the U.S. citizen. Filing a petition for alien relative. When pursuing a K3 visa, the U.S. citizen spouse is required to file 2 petitions with the USCIS. First, he or she needs to file a petition for alien relative, the Form I-130, with USCIS. Upon receipt, the USCIS will send a Notice of Action, the Form I-797. This notice tells you that the USCIS has received the petition. Second, he or she needs to file a petition for alien fiancé, the Form I-129F, for their foreign national spouse. This petition will also include any qualifying children. Please note that after you arrive in the U.S. on your K3 spouse visa, you must continue with the permanent residence process, which generally includes the filing of an adjustment of status application, the Form 485, with the USCIS. Applying for a K3 spouse visa. The U.S. Embassy or consulate where the foreign national spouse of a U.S. citizen will apply for a K3 visa must be the country where their marriage took place. Once the K3 petition has been approved, the file is transferred to the U.S. State Department for visa processing. The National Visa Office will advise you on the procedures that have to be followed for visa processing. The embassy or consulate will let you know any additional things required at that specific post, such as where you need to go for the required medical exam. The following is required for the application. 2 copies of the Form DS-160 in a non-immigrant visa application. These are now actually done online. Police certificates from all places where you've lived since the age of 16. Birth certificates for each applicant. A marriage certificate for the foreign national spouse. Death and/or divorce certificates from any previous spouses for both the petitioner and the beneficiary. The medical examination, except for the vaccinations. A passport valid for travel to the United States and with validity dates of at least 6 months. 2 non-immigrant visa photos, 2 inches or 50 by 50 millimeters square, showing the full face against a light background. Proof of financial support. Form I-134 Affidavit of Support is usually required. The Affidavit of Support, the Form I-864, is not required for the K3, K4 visa, but will be needed when the foreign national spouse files for adjustment of his or her status to permanent residency. The consulate has complete discretion in determining what types of documents are acceptable for the Affidavit of Support purposes. After After admission into the U.S., validity, duration of stay, and extension of stay on a K3 visa. The K3 non-immigrant visa is a multiple entry visa, valid for 2 years. You may apply for an extension of stay while in the U.S. on a K3 visa. This is done using a Form I-539, application to extend or change non-immigrant status. The application for an extension should be submitted to the USCIS at least 120 days prior to the expiration of your authorized stay. Extensions will be granted in 2-year intervals. Employment while on a K3 status. A foreign national spouse in the U.S. in K3 visa status can accept employment in the U.S. You may apply for an employment authorization document using Form I-765, application for employment authorization. This can be submitted immediately upon arrival in the U.S., concurrently with your adjustment of status application, or after submitting your adjustment of status application. In addition to, or as an alternative to, seeking employment, you can pursue full or part-time studies while waiting for the issuance of an immigrant visa. Your adjustment of status. After you arrive in the U.S., the foreign national spouse may apply for an adjustment of status using Form I-485, application for adjustment of status. It is not necessary to wait for the Form I-130 to be approved before you file the I-485. Change of status. A K3 and K4 visa holder cannot change their status to any other non-immigrant visa category while in the U.S. Social Security numbers. K3 and K3 visa holders will need to receive their EAD before they can apply for a Social Security number. The Social Security Administration may not accept the K3 or K4 visa as proof of eligibility. Travel outside the U.S. K3 and K4 visas are multiple entry visas, so the foreign national spouse and his or her children can travel outside the U.S. and return using their K3 and K4 visas respectively. A foreign national in a K3 or K4 visa status can travel on the K3 K4 visa even after filing for adjustment of status and do not need to file for advanced parole. Let's look at some pros and cons of the K3 spousal visa. Like every other non-immigrant visa, the K3 has advantages as well as some drawbacks. But overall, the positive aspects win out over the negative ones. So what can you have so that you can have a clear view and better understanding of the K3 non-immigrant visa category? We have listed some of the pros and cons. On a K3 visa, you can reside in the U.S. with your family while waiting for the approval of your immigrant visa petition, apply for a work permit, travel outside the U.S. on short trips and re-enter, study in the U.S. On a K3 visa, you cannot change to any other non-immigrant visa status, enter the U.S. if you have been temporarily barred for previous violations of immigration laws. In summary, the new K3 spousal visa regulations have helped substantially shorten the processing time for a foreign national spouse to get a visa to live in the U.S. with their U.S. citizen family, from what was years down to months. The actual processing time depends on the country in which the foreign national spouse is applying for his or her K3 visa. The consulate where you must apply is controlled by where the foreign national spouse resides and where the marriage took place. The K3 visa process involves a number of tedious steps and can be complex and at times unwieldy. Any carelessness can cause unforeseen trouble during the processing of the K3 visa, which would then make it difficult for you to identify, locate, and resolve the problems. However, you can bring your foreign national spouse to the U.S. to live with you while waiting for the non-immigrant or the immigrant visa process to be completed in the shortest time possible by seeking expert consultation from a qualified immigration attorney. It is therefore of high importance that you take great care and precautions in completing and filing your K3 visa petition and application. Contact Visa Pro if you have questions about the K3 spouse visa or what steps you should take to successfully obtain one. Our experienced attorneys will be happy to assist you.